Go away.
All right, Mr. Bonamy, are you able to hear me okay?
Yes, Your Honor.
All right, looks like we've got everybody. Oh, no, we got to wait for Mr. Brown here to connect. Okay, Mr. Brown, are you able to hear me okay?
Yes, I am, Judge.
Okay, we've got everybody connected. We're on the record now in People versus Casey Bonamy. This is case number 216097. The record should reflect that Mr. Bonamy is present today by video from Otsego County Jail. If I could have counsel put your appearances on, please.
Amanda Brooker appearing on behalf of the people.
Larry Brown on behalf of Mr. Bonamy.
Okay, and then we also have Ms. Davis present here from probation and parole. And Ms. Davis, you're the supervising agent, is that correct? Sorry, I'm not sure if your microphone is connected.
Can you hear me now?
There we go. Yep. Okay, thank you.
Okay,
So-
I am supervising this case, yes, Your Honor.
Okay, so I just want to make sure that I'm correct on the procedural status. So it looks like back in March of 2023, there were some alleged violations. Mr. Bonamy was arraigned on those. And then during the course of those proceedings, he failed to appear, I think in December of 2023 and then in January of 2024. And so an additional violation was authorized on January 9th of 2024. And so that's the violation that we're arraigning on today. So essentially we'll have two sets of violations. Is that correct?
That is, Your Honor.
Okay. All right. So Mr. Bonamy, and then Mr. Brown, I believe Mr. Bonamy's already had counsel appointed on the underlying, the first set of violations. And I believe that's Mr. Gilo. Is that correct?
Believe so.
Okay. All right, so Mr. Bonamy, I need to go through a few things with you with regard to your rights. First of all, you do have the right to have a hearing as to whether it or not you violated your probation by failing to appear back on January 4th of 2024. You have already been appointed counsel, and Mr. Gill will continue to represent you, although Mr. Brown is here today for purposes of arraignment. If you are found guilty of this additional probation violation, it could subject you to the maximum possible penalty on your underlying charge, which in this case is up to 7 years. Do you understand that?
Yes, Your Honor.
Okay. Mr. Brown, have you had any opportunity to speak with Mr. Bonamy? I know that this matter was scheduled pretty quickly here this morning.
I have had an opportunity to speak with him, Your Honor.
Okay, and does Mr. Bonamy know how he wants to proceed today?
In all candor to the court, Your Honor, if we could address the issue of bond first, it may determine how we proceed.
All right, Ms. Davis. Yeah,
Maybe if I update the court, maybe we could have a resolution today.
Okay.
So this is a 2021 case. Numerous failure to appears. He has 2 domestic violence arrests while he's been on probation. Absconded again. When he was arrested this time, the ARU MSP trooper said he was under the influence. He was very concerned about going through withdrawals. I am today, well, I should update as well. There is a failure to appear bench warrant out of Alpena for a domestic violence second where he failed to appear for court there. I have been in contact with the magistrate in Alpena because it is not in lien, but it is a valid warrant that he failed to appear for court there. So they are trying to fix that. So I am to the point with Mr. Bonamy that if he pled guilty to the failing to report, we can dismiss all of the other violations, discharge him unsuccessfully. His sentencing guidelines are only 0 to 6 months. And he is entitled to 144 days jail credit as of today. So if that
Okay.
helps the court and Mr. Brown, and if we could proceed from there, or we could set a bond and set this out for a hearing at another date.
All right, thank you. Mr. Brown?
Again, Your Honor, I did not know any jail credit. We did talk about the guidelines and his possible positions here and how he could proceed. I imagine that we're going to have a resolution, but Mr. Bonnaby would like to hear the bond recommendations before we proceed.
Well, I mean, I don't need to hear any bond recommendations based just on what Ms. Davis has said about his pending charges, his pending failures to appear, all his failures to appear in this case. The court's going to set a high cash bond until this is resolved one way or the other, because I don't think it's not in the community's best interest to have Mr. Bonnaby released before this matter is taken care of. He's been at large since January. So I don't need a recommendation. I can tell you right now, I'm going to set a bond that's high enough. Mr. Bonnaby won't be able to post it.
Your Honor, based upon that information and my conversations with Mr. Bonnaby, I believe we are going to enter a plea today.
All right, Mr. Bonnaby, I know you've been raising your hand. I don't know if you want to speak, but I'll give you that opportunity.
Hi, yes, sir, Your Honor. So since December, I was discharged from Harbor Hall for medical reasons. They found that I had sepsis, and then when they were doing tests on the sepsis, see what else was wrong with my organs, they found cancer, and I've been hospitalized 30 times since.
Yeah, so
December.
I don't.
Mr. Bonnaby,
None of that really matters today.
Well,
I just need to know whether you want. I just need to know whether you want the court to set this for a hearing, or whether you want to plead guilty today, or whether you'd like to have more time to speak with your attorney.
Well, I like more time to speak with my attorney.
Okay.
I'm not.
All right.
But
So the court's going to enter a not guilty plea on behalf of Mr. Bonnaby here today. The court will set this for a
I
hearing.
don't understand none of this. I don't understand it.
Mr. Bonnaby,
I'll do whatever Mary recommends.
I can't.
Whatever.
I'm
Your
muting
Honor,
Mr.
just-
Bonnaby. I'm not
Your
able
Honor.
to. Yeah.
I mean, he's perfectly entitled to set it for a hearing. I did have this conversation with Mr. Bonnaby. It was my understanding that he was going to enter a plea, especially if he was not going to be able to get out of bond, which that does seem to be the case. The things that he was mentioning previously are arguments for sentencing, not necessarily adjudication. And I did have that conversation with him.
Yeah, so here's where I'm at. I'm in the middle of a trial. I've got to go back on the record in the trial in 10 minutes. Mr. Bonnaby doesn't sound to me like he's real clear on what's happening. I'm not sure what kind of state of mind he's in right now, and I'm not frankly satisfied that he's going to be able to knowingly and voluntarily enter into a plea today. And I don't have time to, at this point, to spend a half an hour trying to figure out if he knows what's happening right now. And it's my view, just in my short interaction here, and his inability to kind of follow directions, I can see he's still talking. I'm not satisfied that we're going to get a knowing and voluntary plea based on his mental state and potential use of substances. And again, frankly, I don't have time to try and work through that right now. So the court is going to enter a not guilty plea on his behalf. The court's going to set bond in the amount of $50,000 cash or surety. The court will set this for a hearing within 14 days pursuant to statute. Assuming Mr. Bonnaby's not going to be able to post that bond. And then we'll go forward from there. That'll give Mr. Bonnaby an opportunity to further speak with counsel, which he has requested here on the record today. That'll give the court another opportunity to assess his mental state to make sure that he's going to be able to knowingly and voluntarily enter into a plea, if that's the way we're going to go. And if not, Mr. Bonamy has retained his right to have a hearing. In which case, if he's got arguments based on his health conditions and so forth, as he started to indicate today, that may be a basis for finding that he didn't violate his probation. So for all those reasons, that's how the court is going to proceed. The court will notify all counsel of the date and time of that hearing, and then the court will fill out that bond paperwork shortly. Ms. Bruker or Ms. Davis, anything further from your side for the record today?
No, Your Honor.
Thank you.
Mr. Brown?
No, Your Honor, thank you.
All right, thank you. That's all for this hearing today. All parties are free to disconnect.